Section 7. Legal Hotline Q&A, Arizona Commissioner's Standards, Requirements for Licensees. Introduction, When Good Intentions Cross Legal Lines. Jessica thought helping people was always a good thing. A friend asked her to just write up a contract. Another agent in her office talked about doing side deals outside the brokerage. Someone else mentioned adjusting commissions to make the deal work. At first, all of it sounded reasonable, helpful, even normal. But in Arizona real estate, intent does not matter as much as compliance. This section focuses on real legal hotline scenarios where agents believed they were doing the right thing, but legally, they were wrong. These are the situations that don't feel like violations until Adre gets involved. Licensee cannot draft documents for a fee outside a transaction. A licensee's friend finds a property being sold by owner and asks the licensee to draft the purchase contract for $300. No representation, no brokerage involvement. Just helping out. The answer is no. Under Article 26 of the Arizona Constitution, a real estate licensee may draft documents only when acting as a broker or agent in a transaction, and those documents must be incidental to the transaction itself. Even in that case, the licensee cannot charge a separate fee for drafting those documents. This is where many agents get tripped up. They assume their license allows them to prepare documents anytime. It does not. The authority to draft documents is tied directly to representation and brokerage involvement, not convenience or side income. Jessica realized quickly, what seemed like an easy $300 could actually be a violation of constitutional law. Commission disputes do not require brokers to reduce fees. A seller agrees to pay a 6% commission. The listing broker agrees to split 3% with the buyer's broker. At closing, the seller demands that the listing broker reduce the commission to 4% or the deal won't close. Neither broker agrees. Are they required to reduce their commission to save the deal? No. A listing agreement is a contract, and both the listing broker and buyer's broker have enforceable contractual rights. They are not required to reduce their commission simply to facilitate closing. However, there is an important professional standard to understand. Under AAC R4-28-1101D, a licensee should not allow a commission dispute to jeopardize a transaction. This creates a balance between legal rights and professional responsibility. The key takeaway is that while brokers are not legally required to reduce commission, how they handle the situation reflects on their professionalism and risk management. Broker, not always responsible. When agent acts personally. An agent owns multiple lots and is selling them personally while properly disclosing that they are an owner-agent. The question becomes whether the broker is responsible for those transactions. The answer is generally no. If the agent is acting on their own behalf and not representing another party, the broker is typically not responsible. However, this changes quickly if the agent creates the appearance that the brokerage is involved. If the agent meets clients at the brokerage office, uses brokerage branding, or otherwise suggests brokerage involvement, then apparent authority may be created and the broker could be pulled into liability. This is where small details matter. Something as simple as handing out a business card with the brokerage name during a personal transaction can blur the lines and create risk. Broker must maintain a definite place of business. A broker operates out of an executive suite, but only rents office space occasionally when needed. There is no permanent office location. Does this meet Arizona requirements? No. Under ARS, paragraph 32-2126A, a broker must have and maintain a definite place of business. Occasional use of shared office space does not meet this requirement if there is no consistent, dedicated location. Adre interprets this strictly because the public must have a reliable place to locate the broker. A floating office or occasional meeting space does not provide that level of certainty. This is a compliance issue that often goes unnoticed until an audit or complaint occurs. Counseling and advising is considered real estate activity. A licensee starts an investment company, teaches seminars on fix and flips, and helps investors find properties, but does not run any of this through their brokerage. The question is whether this is allowed. The answer is no. Arizona law defines real estate activity very broadly under ARS, paragraph 32-101. It includes not only selling and negotiating, but also advertising, counseling, advising, and assisting in real estate transactions. This means that even teaching, guiding, or helping investors can fall under licensed activity. If it involves real estate and compensation, it must go through the brokerage, and the broker must supervise the activity. Jessica realized this was one of the biggest misconceptions in the industry, agents thinking they can separate education or investing from their license. In reality, those activities are often still regulated. Referral brokers are not required to maintain transaction files. Broker A refers a client to broker B using a referral agreement. After closing, broker A requests the full transaction file. Is broker A legally required to maintain that file? No. Under ARS, Paragraph 32, 2151.01, brokers are required to maintain records for transactions handled by or through their brokerage. In a referral situation, broker A did not handle the transaction. They simply referred the client. Therefore, they are not required to maintain the transaction file. However, referral agreements may include provisions allowing the referring broker to receive certain documents, such as the closing statement. This is a contractual matter, not a statutory requirement. Bringing it all together. The line between helping and violating. Every scenario in this section highlights a common theme. Agents often cross legal lines while trying to be helpful, efficient, or creative. Drafting documents for a friend, working outside the brokerage, adjusting commissions under pressure, running side businesses tied to real estate. None of these feel like violations in the moment, but under Arizona law, they can be. The difference between a successful long-term career and a disciplinary issue often comes down to understanding one simple concept. If it involves real estate activity and compensation, it must follow the rules. Jessica walked away from these scenarios with a new mindset, not just how to close deals, but how to protect her license while doing it. Online discussion. 1. Why is a licensee not allowed to charge separately for drafting documents outside of a transaction? Answer: because the authority to draft documents is limited to representation within a real estate transaction and is considered part of the licensed service, not a separate compensated activity. 2. What is the risk of an agent conducting real estate-related activities outside of their brokerage? Answer: the agent may be engaging in unsupervised licensed activity, which is a violation of Arizona law and can lead to disciplinary action against both the agent and the broker. 3. Why does Arizona require brokers to maintain a definite place of business? Answer: to ensure accountability, accessibility, and transparency so that clients and the public can reliably locate and interact with the brokerage.